There has been a new development in the Kartel saga. Vybz Kartel is still one of the most influential DJs in Jamaica's entertainment industry. Vybz Kartel and his music remains extremely popular, not just in Jamaica, but globally as well. Jamaican dancehall DJ Vybz Kartel, whose real name is Adidja Palmer, was recently granted leave, along with his co-accused, to go to the Privy Council to appeal their case. The judgment was recently handed down in a virtual hearing of the downtown Kingston-based Court of Appeal by Justice Nicole Simmons. Adidja Palmer, more popularly known as Vybz Kartel, along with fellow entertainer Sean Storm Campbell, Andre Sean John, and Kahira Jones, were given life sentences in 2014 in relation to a serious matter that was presented before the court in relation to Clive Lizard Williams in 2011. In April, 2.5 years were taken from their period of eligibility for parole. Vybz Kartel was initially given 35 years before being eligible for parole. That time was reduced to 32 years and 6 months. St. John, who had to serve 30 years before being eligible for parole, had received a reduction in his sentencing to 27 years and 6 months. Sean Storm and Kahira Jones, who had been given 25 years prior to being eligible for parole, had their time reduced to 22 years and 6 months. Vybz Kartel and his co-accused have been granted conditional leave to go to the Privy Council in the United Kingdom to challenge the mandatory life sentences that were handed down to them in 2014. However, the decision that was handed down by the Court of Appeal also comes with a few conditions, and one of these conditions is that they must file all the necessary documents in the case within the next 90 days. They are also permitted to put some important issues before the court. Now, some of these issues include the Charter of Fundamental Rights and Freedoms and how this charter affects the court's authority to admit into evidence material that they obtained, secured, or collected which were in breach of the rights and freedoms that the Charter guarantees. They will also be able to put this question before the court: how, if any at all, does the answer to the question of the Charter of Fundamental Rights and Freedoms being breached affect the admission of evidence which was obtained in breach of the right to privacy of communication and the Interception of Communications Act. The third issue which may be presented revolves around how inquiries involving jury misconduct are to be handled when they arise, and also a fourth issue would revolve around the convictions of the applicants for the crime of which they were sentenced, and if this is unsafe as a result of the trial judge's mismanagement of the issue of jury misconduct which occurred during the course of the trial, specifically the procedure that was adopted and the extent of the inquiry that was conducted. They would also be focusing on the trial judge's refusal to discharge the jury or any juror following his inquiry into the issue of jury misconduct. Also, an issue that may be investigated involves any inadequacy in the trial judge's directions to the jury following the inquiry into the issue of jury misconduct, and the failure of the Court of Appeal to expressly demonstrate its findings and conclusions in respect of the fresh evidence that was adduced concerning the issue of jury misconduct at the trial. Fifth issue, which may be presented to the Privy Council, revolves around the principles that govern the latest time at which a jury may be asked to retire to consider its verdict. How this time would affect the convictions that were handed down to these applicants. Ija Palmer, Sean Campbell, Kahira Jones, Andre St. John, and all attorneys on this case are extremely happy with the court's decision. It should also be noted that more than 40 questions have been submitted for referral to the Privy Council. These questions are directly related to the breach of the rights and freedoms that the Charter of Fundamental Rights and Freedoms guarantee, as well as the admission of evidence which would have been acquired in breach of the right to privacy of communication, as well as inquiries involving jury misconduct and how the trial judge would have managed these inquiries, and how these inquiries would have affected the applicants, as well as the principles that govern the time at which a jury may be asked to retire to consider a verdict, as well as how this time would affect the convictions that would have been handed down to the applicants in the case. It should also be mentioned that an application seeking to go to Jamaica's final court of appeal, the Privy Council, would have been filed in April after the appeal for these men were rejected. As the saga continues for Vybz Kartel and his co-accused, we will see how the Privy Council responds to all of the 40 questions that were submitted by the various attorneys for each applicant. And of course, we will see how this case will provide precedents for future cases in Jamaica and any other jurisdictions that are subject to the Privy Council as their final appellate court. Now like, comment, share, and subscribe. Leave your comments down below and let me know what you think about this recent development in the Kartel saga and him seeking to challenge the court's decision to hand down mandatory life sentences.